work. Good morning. This is Judge Elisa Bettis presiding over the 210th District Court civil docket for September 11, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call our case. And as I do that, I want to thank everybody for accommodating a change in schedule as well, because I knew we had a regular docket, so I want to make sure you all had enough time. Calling cause number 2022 DCV 0886 Eduardo Cabral et al. Versus My Universe Inc. et al. May I have announcements, please?
Yes, Your Honor. This is Brennan Villanueva on behalf of the plaintiffs.
Good morning.
Good morning.
Good morning, Your Honor. This is Dan Hernandez on behalf of My Universe and Kushbal Singh.
Good morning, Your Honor. This is Sebastian Uribe on behalf of RV Share LLC.
Mr. Uribe.
Kurt Paxson for Defendant Expeditors International of Washington.
This is John Dickey. Oh, sorry. John Dickey, Defendant Joseph Jackson.
Elena Esparza, also for Expeditors, Your Honor.
Your Honor, Carlos Rincon, and I'm here with co-counsel Brian Cathy for Landstar, and I have a client representative, Mr. Jeff Peterson, is attending in observance, and then I have Roberta Guido and Richie Casas from my office as well. Thank you.
Good morning, everyone. We are scheduled for several motions. Let me get into my new Odyssey here, so I can just pull up. I have, well, where are we going to start? Who wants to help the court?
I have a suggestion, Your Honor, but I don't want to overrun my coverage. So there are, as I understand it, 3 motions that are on top: a motion to compel and a request to abate the motion for summary judgment filed by Expeditors. Then you have the Expeditors motion for summary judgment. And then you have the Landstar Ranger motion for summary judgment. And then in addition to that, Your Honor had set this matter for a status conference. I think we were set last week, but it got morphed into this one because we are set for trial November 8th. And just real quick, Judge, and if I could, I think it would just make logical sense for the motion to compel to go first, because I'm asking for an abatement of one of the summary judgment motions. So depending on how you rule on that, could make one of the motions moot for today. And then there's the Landstar motion for summary judgment.
Judge Kurt Paxson here. I think that we've sidestepped a lot of Mr. Rincon's problem. We're not moving on our traditional motion today. We're only here on the no evidence motion, and he has no say in that. So we're not going to get into his issue at all.
And Your Honor, I respectfully disagree. So just we can get into that when you ask us to.
Sure. So let's start with that motion to compel. And I was just trying to cross-check as you all were speaking to look for, I guess, the most recent filings. And I do see something about 2 days ago. I was trying to cross-check to see if I had that in a binder. There's a reply on Expeditors.
We did deliver a motion to compel, and then also the motion for summary judgment and our response to the Expediter motions in binders to your chambers.
Correct. And I have those. What I was looking for was there is I believe, Expeditors. Oh, let me see. A pleading filed. Oh, it says in September 6th.
Yeah. Judge, both Expeditors and the plaintiff filed a response to that motion by Mr. Rincon.
Okay. All right. Mr. Rincon, you may proceed on that motion to compel.
Yes, Your Honor.
Your Honor, may I time out real quick? I have to step away at 9:30. Our associate Connor Allen, who just signed in, is here for me, Judge, but I'll be right back after. I've got another engagement at 9:30, if that's okay with Your Honor.
No worries, of course.
Thank you, Judge.
Okay.
Your Honor, and I will endeavor. Okay, I won't. I'll wait till I'm called upon. Am I able to speak?
Yes, sir. Yes, sir.
Okay, Your Honor, Carlos Rincon for Movement, Landstar Ranger, and I will endeavor to be brief. We filed a motion to compel witness testimony and document production. In addition, we've asked for a remedy. It's a 215 sanction, but it's not, we're not asking for a monetary sanction or an admonishment. What we're simply asking the court to do within its discretion under the rule is to abate, postpone the hearing on expediter's motion for summary judgment until we ultimately are able to take the deposition of the person with knowledge and get the relevant documents that Your Honor has ordered be provided. So that's bottom line. I read everything, Your Honor. It is extremely voluminous. I'm going to endeavor to be very succinct, but I wanted to show you, to start off first by showing you a little chart that I created this morning. And what it intends to do is describe the discovery that has been undertaken with expediters. And if I may have Mr. Costas share screen, I'd like for him to show a drawing, little chart. So, Your Honor, in the motions and the responses, there's been a suggestion that what I endeavored to do is delay and bog things down. I will say there is no delay nor bogging things down. You'll see that I've been extremely diligent in moving this case forward, and I'm not asking for anything other than the depositions Your Honor has ordered proceed forward. But there have been 7 depositions of expediter witnesses. 4 of them, the ones with the star, took place through an interpreter, so naturally the length of time was double. But of the 7, and this leads to why we need relief again from the court, the first 2 depositions I did not notice. They were noticed by, I believe, plaintiff's counsel. I may have cross-noticed them. Aaron Howes is an executive with expediters. He appeared as a records custodian, simply produced what he represented or understood was the file on this matter that involves this shipment of freight. Second, Roberto Martinez is an executive with expediters. He was in charge of South America, Latin America. He had a very prestigious title, nice gentleman, but he did not have any knowledge of the subject incident, nor of the issue regarding the consent to broker loads, which is at the center of one of the central issues in this case. Then we identified 2 people in some emails, Sofia Reyes Martinez and Adrian Maciel. Ms. Martinez is the manager of the Guadalajara expediter office where this load originated, but like Mr. Martinez, had no knowledge regarding the issue of consent to broker loads. And when we deposed Mr. Adrian Maciel, and I had to secure an order from the court to get Mr. Maciel and Ms. Martinez's depositions done, because expediters had set their motion for summary judgment. He, despite being a knowledgeable man, he knows a lot about this case, knows nothing about the issue of consent to broker and deferred to the service provider management team. So the 2 people on the service provider management team, Marco Rodriguez and Emma Lopez is the lead of that team. They both know about the precise issue of consenting to brokering loads, like was involved here. But neither had any knowledge about who at Expeditors was in charge of the Landstar account and who could specifically speak to this issue. Landstar has been an approved service provider with Expeditors since 2010. To get there, we cite the testimony. They would have gone through a very rigorous, comprehensive assessment and security review. They passed with gold stars and started doing the work and still are a service provider. But we have not been able to depose the critical person with knowledge at Expeditors who knows specifically about the Landstar account. The corporate representative, very nice gentleman. He's a professor at UTEP, very accomplished man. He showed up in response to a deposition notice, but surprisingly, he did not know any specifics about this issue of consent to broker loads. And he too deferred to the service management team that's led by Ms. Lopez. So from Adrian Maciel, he identifies Emma Lopez. The corporate representative identifies the service provider management team, which Emma Lopez heads. But when we went to go depose Emma Lopez and her subordinate, her assistant, Marco Rodriguez, neither of them had any information about the Landstar account. Both deferred us to someone in corporate Expeditors offices in Seattle. So I want to just demonstrate to the court these 7 depositions. They're not voluminous. We gained very critical information, but we're one piece away, and it's essential to the disputed issues in this case, including the issues that Expediter is including in their motion for summary judgment. And I'll get into that briefly here next. I want to next show, Your Honor, the deposition notice for the corporate representative that I have issued. So we could pull that, Mr. Cáceres. I think it's an exhibit to the motion to compel. I think it's exhibit 10. If we scroll down, it's a very comprehensive notice, Your Honor. And if we scroll down to this deposition notice, I want to get to the topics that I delineated for inquiry. And it was a timely notice. There were no objections to speak of to the notice. But if you look at, and I'll draw Your Honor's attention to item 1, item 4, and item 10. Item 1, terms of the service provider agreement of October 2010, and there was a supplemental one in April 2012, and any more recent service agreements, which we did not have at the time early on. We just recently located those and supplemented them, but have never been provided to us by Expeditors. And that is that govern the authority and the agreement by Expeditors and Landstar to move freight, the subject of this case. And then item 4, we asked for information regarding the motor carriers that move the freight from Guadalajara up to the U.S.-Mexican border. And I also want to bring to the attention of the court item 3. We could scroll up to item 3. So in the response to the motion to compel, there was a suggestion that this notice wasn't specific enough. And this item 3 reads, I want to speak to a witness on compliance, enforcement, or waiver of the terms regarding the provision that reads, service providers shall not broker any loads without the consent of Expeditors, and specifically quoted a page and line from the deposition of this executive from Expeditors. He did not have that knowledge. He was pointed to an exhibit that Your Honor has seen. It says no brokering of loads without written consent. We have since located other documentation that was issued to Landstar by Expeditors that speaks to requiring written consent only in cases where a subcontractor is going to subcontract the load, which in this case did not apply. But the point being, the way this notice is framed, Your Honor, it's broad enough to cover the topic of inquiry, which is this precise issue of what were the rules that expeditors had to consent to brokering loads? What was the process? What's the criteria? What paperwork is generated? We asked for corresponding documentation. And other than some very select documents that were produced by witness House, we have never received this. Now, if we go down to number 10, I asked for another scroll down. And it's not moving. Oh, there it is. Okay. Specifically, whether expeditors waived or enforced the brokerage prohibition in this case against Landstar. If so, why so? If not, why not? These are the very germane issues in this case, Your Honor. We can't be any more specific. The rules don't require that we actually write out the questions in the notice, just the topics. Again, not objected to. We go to the deposition of Mr. Martinez. I've cited all the relevant testimony in the motion. He didn't have a clue about these specifics and deferred us, as the chart shows, to Emma Lopez, the lead of the service provider team. So we go and depose Emma Lopez. I even had to get a court order to get her deposition taken before hearing expeditors' motion for summary judgment. And on multiple occasions, her and her colleague, Marco Rodriguez, both swore they had no personal knowledge but the Landstar account. They concede that that would be a good name to know and to share. And they both presume that the person that can speak to these issues is an expeditors representative in Seattle, Washington, which is the corporate corporate headquarters. We've never been provided that critical piece, Your Honor. The inquiry of an expeditors witness that is familiar with the Landstar account is central to this case, and we have never been provided a witness. We've spoken to 7 that has any knowledge about that specific, precise central issue. And Emma Lopez, in the testimony that we cited, Your Honor, stated very succinctly that it would be a fairly easy process of identifying who at corporate is in charge of this account. You've ordered this deposition go forward. We've not been provided the witness. We're not on a limb here. I could take that deposition this afternoon if I had the witness. The lines of inquiry are very specific. Now, I also asked for Mr. Howe's deposition only because they've not produced documents that I think should have been produced. That can obviously be corrected without Mr. House's deposition if they can just get the critical related documents that go along with this issue of onboarding of Landstar and the authority to broker loads that were discussed by Emma Lopez. But we need, at the minimum, the deposition of this expediter witness with this knowledge. If I could, Mr. Costidas, if you could just go next to the motion itself. Your Honor, in the motion that I drafted, I was very careful to just lay out for Your Honor the very specific page and lines of the material testimony that demonstrates the legitimate basis for the motion to compel. Simply that we, as ordered, we went to depose these witnesses, and these witnesses didn't have the requisite knowledge. And here's the thing, they've identified that it would be a person with expeditors in the Seattle corporate office that would have this knowledge. It is vital, and it would be extremely prejudicial to Landstar not to have this opportunity, given it timely requested this witness through a deposition notice. It was not objected to. Emma Lopez confirmed this is information that expeditors could easily produce.
All right.
Yeah, so let me, Mr. Costidas, could you go to our motion? If you could move it to page number 6. On page 6, Your Honor, I draw your court's attention to the testimony of the corporate representative. It's his name is Agustin Bengochoa. And down there, if you scroll down a little bit, we asked them point blank, Mr. Cáceres, go up. Point blank, I asked them, keep going. Are you familiar with the criteria that the service provider management team utilizes to consent or not to consent to a load of freight being brokered, such as to someone like my universe? The answer was no. I next asked them this. The court in this case has ordered that the two members of the service provider management team that I identified, Marco Rodriguez and Emma Lopez, give depositions in this case before June 26th, that's next month. You would agree that they would be better suited to provide these details. And this is the words of the corporate representative for Expeditors. I don't know. And he finishes by saying, yeah. But the reality is there is still not an answer to the central questions regarding how the service provider team operates, and specifically how it operates with respect to Landstar Ranger. And if you could go to page 12, Mr. Cáceres, of the motion. At the very bottom, page 12. Keep going. Keep going down. So that my notes are complete, as you sitting here in your capacity, you don't know who is the custodian. And I'm asking Emma Lopez, the head of the service provider management team, who is the custodian or the person in charge at Expeditors over the Landstar service provider relationship? Her answer, I do not know. Go to page 13 and I'll just reference this, and then I'll just show Your Honor one more document. I asked her on identifying who at Expeditors is in charge of the Landstar account. If you had to find that information out, how would you go about doing it? She says, I would access the system with the providers, service providers are managed, and I would see under what district the custodian falls, and within the district, I would see who's my counterpart. Question, in the course of this lawsuit, have you not been made aware of who at the Expeditors or who the Expeditors manager or custodian of the Landstar relationship is? No. So this is the person that was directed to us by the corporate representative. You would agree that relative to this lawsuit, that's an important individual to identify so that we can speak to them, correct? Answer, yes. And Your Honor, the final point I wanted to show you, because I think it's important. Mr. Cáceres, you go to exhibit number 11. It's the email. So we've demonstrated that we have timely and properly requested this discovery. We have obtained court orders to compelling the production of witnesses with the relevant knowledge. And as it turns out, these witnesses just didn't have the knowledge. That person is likely in Seattle, as per what we've cited in our motion. But I want to close my request here, Your Honor. It's an email that I wrote to Expeditors Counsel on July 6th. It was about 2 months ago, where I reminded them that the witnesses that they had produced did not have the very basic knowledge of how what they described in general terms dialed into the Landstar account. It was unequivocal, and it's not refuted. Crickets, we never got a response. We could have resolved this issue by agreement easily, but it hasn't. And instead, all I received was the refiling of the motion for summary judgment. And I'm still out. I still don't have the witness. And we take great exception to some of the the statements that Expediter makes in its motion for summary judgment, we disagree with. And so, Your Honor, all we want is an opportunity to enforce your orders that have already been entered. We ask for an expediter's witness that can speak to these issues and to the security risk review documents that Emma Lopez swore under oath would have been created by expediters and the onboarding and supplemented each year. We, as part of our discovery, Landstar, supplemented for the record, and we think that these documents clearly are in the possession of expediters because they're expediter documents. Your Honor, that's why we're here. We think we're not looking for delay. The fact that we've taken 7 depositions, it's taken this much work to get here. We need this final witness to conclude this very critical inquiry. We simply ask that the summary judgment hearing be abated until we get this deposition and the documents, and then the motion can be heard. I would be available to depose this witness this afternoon. It probably is a 2 to 3 hour deposition at most. We can do it by Zoom if need be. But that's the relief, Your Honor. We think we're entitled to it, and it's not causing any delay or any burden. Your Honor's already ordered it. We just ask for enforcement.
Judge, may I respond?
Mr. Rincon, yes, Mr. Paxton, you may respond.
And like Mr. Rincon, I'll be brief. Judge, there's one sentence in this contract that is causing him all this heartburn. It says that they cannot broker without written consent. It's that simple. They're not contending they received written consent to broker. And that's a problem for them in this lawsuit. I get it. On the other hand, there's been 7 depositions. Most of those, Judge, he picked out the person that he wanted to depose. Our corporate representative simply stated, we have a service provider agreement. It's signed by us, and it's signed by Landstar Ranger, and it says you can't broker without written consent. I don't think it could be any better said or said any more simply in the English language than that. And so it's so ironic, Judge, that they want us to find this person. Wouldn't Landstar Ranger know who their counterpart was? Wouldn't Landstar Ranger know how to ask for written consent and who to direct that request to at Expeditors? This is something that they endeavored to do when they signed that contract. And so I find it amazing that they have no idea who at Expeditors they should direct that request to. Judge, the corporate representative is the only person that speaks on behalf of the company. He is the person that speaks to policy. And they said it says what it says. They're not here to vary that. And Judge, we all go back to Contracts 101, the objective manifestation of the contract. I don't want to hear about subjective intent. I don't need any parole evidence. That's the parole evidence rule. Let the court look at what the contract says, and that's what it says. Yeah. We don't need to hear anybody's opinion about what it says. The court will divine that. This is as simple as it could be said in the English language. But Judge, that's not even the issue for today. What I've done is I remodeled my motion for summary judgment in an attempt to mollify Mr. Rincon. I tried to sidestep the language that he found offensive. And I sent it to him by email. I said, does this fix our problem? It didn't. He wants to continue with discovery. So then for today's purposes, Judge, the language that he finds objectionable and inflammatory or problematic, throw that all in the garbage can for today. The only motion for summary judgment today is a no evidence motion for summary judgment, in which we all know in a no evidence motion for summary judgment, we don't make any allegation at all against Landstar. We simply negate elements of the plaintiff's cause of action. Now, Judge, we've had other hearings on this case, and a lot of this argument today is duplicative, but I've asked Mr. Rincon, I've challenged him, I go, why do you keep saying that you can somehow oppose my motion for summary judgment? You have no standing. And now, Judge, we have filed a response. There's 2 good Court of Appeals cases that stand on all fours that tell us you can't have a co-defendant oppose their fellow defendant's motion for summary judgment against a plaintiff. They don't have standing under the rules. And so there's nothing in the rule that gives them the opportunity to oppose it. And the case law teaches us you absolutely can't allow a co-defendant to oppose that motion for summary judgment by a co-defendant. So, Judge, I'm in the unusual situation where plaintiff's counsel filed a response and they're not really opposing my no evidence motion for summary judgment. I'll let them speak to their response better than I can. But we are entitled to summary judgment today on the no evidence motion. I think the rule says if there's not competent summary judgment evidence in response to the evidence, the court shall, I think it has mandatory language, grant the motion for summary judgment. Judge, I think the best thing for Mr. Rincon is to ask the people at Landstar who they would contact to request permission to broker a load. And that's the person that I'll produce at deposition. I might not be a part of the lawsuit anymore, but we respond to subpoenas. I'll accept service of process of the subpoena. Okay, as an officer of the court, I'll say that. But again, there's no reason to keep me in as a defendant in this lawsuit.
All right.
Your Honor, if I may.
Oh, okay. Yes, Mr. Bianco.
Yes, the plaintiffs also filed a response to Mr. Rincon's motion to compel and motion to abate. So Mr. Paxton, I think, has very succinctly boiled it down, but I just wanted to make a couple of points for the court. In Mr. Rincon's little demonstrative that he showed you, next to the deponent, he put no knowledge of consent to broker loans. What that really means is they testified they didn't see any consent to broker the loads. That's what they're saying. All of those witnesses have said that. The corporate representative in my motion, I asked him, and you're telling us today under oath that there is no written consent that Expeditors gave to Landstar to broker the load. And he said, correct. So what does it matter what the process would be? What does it matter all of these collateral issues? There's no consent there. As Mr. Paxton says, what Mr. Rincon wants to do is he wants to find an Expeditors witness that he can artfully, retroactively say, oh yeah, we gave consent. But so far, none of the 7 have done that. And that's what his problem is. The second thing I want to point out is that the contract between Expeditors and Landstar that says specifically you must have written consent to broker loads has never been produced by Landstar. They claim they don't even have it. If anyone in this case is not producing evidence, I think it's Landstar. And I don't think Landstar wants to produce it because they know that language is in there. The third thing that I want to point out is the documents that he's telling the court that he wants to examine all these Expeditors witnesses on, the compliance certificate, those sorts of things. Landstar's had those documents since before this incident even occurred, before the lawsuit even occurred. Why didn't he ask the corporate representative about that? Why does he waited 2 years to say, oh, well, we have some documents here. Let me ask him about that. But let me tell you this. The people he's deposed, they've said those documents aren't written consent. We haven't seen written consent. I asked Landstar in a discovery request, please produce the written consent to broker this shipment. And their response was, we do not have any responsive documents. There is no consent. That's it. We don't need to continue dredging the lake here to retroactively find some way that Landstar can manufacture consent. It just didn't have it. And just to reiterate Mr. Paxton's point, if it did, Landstar could provide its own witness, its own documents. It would have those documents too. So this is a delay tactic. Regardless if Mr. Rincon can do these depositions this afternoon, I'm glad he's available this afternoon. I'm sure many of these attorneys that are on this call are not available this afternoon, or the witnesses. And where does it stop? When that witness doesn't give him the retroactive consent that he wants to concoct, what then? Another witness? And then what happens supposedly if he gets what he wants? Are we back here for another summary judgment? Is there more pretrial motions? This case is set for November 8th. I have 9, I actually have 10. I have 10 plaintiffs who are eagerly awaiting their day in court. 9 of them were in this RV and injured. 1 of them died. His mother makes the 10th plaintiff. They are ready to have this go to trial. This incident occurred December 31st, 2021. We are coming up on the 3-year anniversary. Mr. Rincon's had the documents since before this incident occurred. If he claims there's written consent, we would have seen it. If he has a witness that said expediters gave us written consent, we would have heard that witness, whether it be an expediters or a Landstar witness. It's time, Your Honor. We need to move forward. And the very, very last thing, I take exception to this, and I'm sure Mr. Paxton does, but I take a little bit of exception, I think, on his behalf. Mr. Rincon has insinuated that expediters has not complied with the court's orders. The court ordered them to produce named witnesses. Please produce Adrian Maciel. Please produce Sofia Reyes. Please produce Emma Lopez. Please produce Marco Rodriguez. And what did Mr. Paxton do? He produced those witnesses. Because the witnesses don't say what Carlos wants them to say, doesn't mean they didn't comply with court orders. So with that, Your Honor, let's move on. I'm ready to do Mr. Paxton's MSJ. I'm ready to do Landstar's MSJ. And quite frankly, I'm ready to get this case in the position where we can try it on November 8th. So thank you, Your Honor. I appreciate the time.
Your Honor, may I just have 1 minute rebuttal? With your permission?
Yes, sir. Yes.
Yes, Your Honor, there was significant opposition to this motion to compel. And I think it's telling that expediters actually really brought no evidence or no argument in response to the motion to compel. Rather, it relied on the plaintiffs to formulate a response in opposition. And the reason that occurred, Your Honor, is that expediters has no good reasoned explanation of why, after being ordered to produce a witness or witnesses with personal knowledge on one of the salient issues in this case, namely, what was the arrangement between expediters and Landstar relative to consent to broker loads of freight. That is why this motion was filed. I did, as their witnesses told me and told the court, we needed to do. We went to the two people that we were told had knowledge about the Landstar account, and when we deposed them, they did not have any personal knowledge. What they said is that the person with personal knowledge is, number one, easy to identify, and number two, likely in the corporate office of expediters in Seattle, Washington. And that's just material fact. So despite the orders and despite the efforts I've undertaken, that inquiry has still not been answered. I wanted to just show Your Honor one excerpt from one document. Mr. Costas, could you pull up page 3, the expediter security and safety standards? When we took the deposition of Miss Emma Lopez, she indicated, and you can start with number 1, so I'll introduce the document to the court. She indicated that when a service provider like Landstar is onboarded, one of the things that is discussed is whether they will be using subcontractors to broker freight. And in the agreements, Landstar is contractually entitled, they have the right to use a subcontractor for any of the services it would be providing to expediters. And in this case, they subcontracted the motor carrier function to My Universe. But on this issue, and the reason we need to probe further and close this loop, on the security and safety notice document that would have been issued to Landstar by expediters as part of the expediter process, it says, relative to written approval, that there not be subcontracting any service being performed for expediters beyond a second party without prior written approval. That wasn't involved in this case. The point being, the only time written approval is required is when a subcontractor wants to itself use another subcontractor. In this instance, Landstar was the service provider, My Universe was the subcontractor, if my universe wanted to subcontract to its own subcontractor, that is when written approval would be required. If you go to page 3, it actually tells us when written approval is required. Section 1.04, when written approval is required. Service provider, that would be Landstar, must not subcontract any service beyond a second party, like another subcontractor, without prior written approval from expediters. Service provider must communicate to all of its subcontractors that they are not permitted to further subcontract any service unless approved in writing by expediters. So in this case, what is required for written consent, if my universe had subcontracted to another subcontractor, that is when written approval, written consent would have been required. You can pull that down. We asked the expediter witnesses, describe the process that a service provider like Landstar would go through to secure written consent to broker a load. Collectively, the answer was, I don't know. We asked these witnesses, describe the process, the methodology that the service provider management team utilizes in approving or disapproving a written request to consent to broker a load. Collectively, the answer from these expediter witnesses was, I don't know. Regarding, are there written guidelines that instruct the service provider management team how to give or not give consent? No one knew. But what Emma Lopez said, Your Honor, which ties into what I just showed you, is that Landstar, upon being onboarded in 2010, would have been given the authorization then to broker loads. And she also stated that on a load by load basis, written consent was not required by virtue of the fact that they had already been approved and onboarded successfully in 2010 and completed the security risk review. So naturally, I asked Ms. Lopez, let's talk about the security risk review for Landstar. She had no personal knowledge. And the reason this is, and with all due respect to Mr. Paxson, the reason this is material to all of the statements in expediters' pleadings and motions, including their no evidence motion for summary judgment, is that they make the erroneous statement that Landstar was retained by expeditors in the capacity of a motor carrier. They also make the erroneous statement that Landstar did not have consent to broker loads. We know, based on the general description of the policies and the documents Landstar is located, these are not Landstar documents. They're expediter documents that were given to Landstar. We know from that sworn testimony and these documents, those statements are false, categorically. We want to speak to, we have requested, Your Honor has ordered, and we have still not been able to take the deposition of the expediter's corporate witness that can speak to these issues. I have run my course. There isn't anything more as a lawyer I can do. And I went long earlier because of the firestorm of allegations that were raised about dilatory tactics, delay, duplicative discovery. None of those allegations or arguments have any merit. So with that, Your Honor, we respectfully request for the relief that we've set out in our motion.
Judge, if he asks for a minute, I'll ask for half a minute, if I may. Judge, what he just read to you is a general subcontract that's not applicable to Landstar, and I think he knows that. Landstar has a specific additional exclusion in the service provider agreement that was signed by them that says that they need written consent to subcontract. Now, Judge, let me say this. I want to be very clear because I don't need to lock horns with Mr. Rincon any more than I need to. What we may call a carrier may or may not be the carrier duties as to the plaintiff, okay? They have duties to us that they would not have to a third party. That's a completely different ball of wax. this happens a lot in construction contracts. We have a contractor and a subcontractor, and the subcontractor's duties of the general contractor, but those are not the duties to the third party claimant necessarily. And I've tried to educate my opposing counsel about upstream contracts and what that means. Judge, the issue as to us is very, very simple. We didn't know that Landstar had brokered this load to my universe. We didn't know, when he asked about, what do you know about the incident? We didn't know anything about the incident. This was not an incident involving an expediter's load until we found out that there was damage to the cargo. And when there was damage to the cargo, that's when our people at corporate found out about it. And we asked Landstar to make right the damage to the cargo. And that was the extent of it. Little did we know that somebody had perished in this accident, people had been injured in this accident. We didn't know any of that. That wasn't like, we didn't get a phone call in the middle of the night telling us that a vehicle involving one of our loads was involved in that. Because again, we give it to them and they're supposed to go ahead and take it from point A to point B. Judge, I don't need to get into the subcontracting issue at all on my no evidence motion for summary judgment. That is not an issue in my no evidence motion for summary judgment. My only issue is what the plaintiff did or didn't say in their response to the motion for summary judgment. I think it's clear that we are entitled to the no evidence motion for summary judgment today. And I've taken down all of the things that Mr. Rincon has objected to in the traditional motion for summary judgment, where we recite facts and provide evidence like documents and affidavits and things like that. But again, Judge, I think we are entitled. If the court allows another subpoena to go out, we'll respond to it. But Judge, I'm not talking to people at the station. I'm talking to people in the general counsel's office. I'm talking to the people that drafted the service provider agreement that contains that language. And again, I would think that Mr. Rincon's client would know better than anybody who they contacted to request consent for this load, or if they had received something indicating that they didn't need consent for this particular load. I think that would be within the exclusive, not exclusive, but the equally available knowledge of Landstar. It takes two. There's two parties to the agreement. There have to be two parties to a request and acceptance of consent. So again, Judge, I don't think I'm needed as a party of this lawsuit any further, but we will respond to any subpoena that's issued by Mr. Rincon going forward.
Mr. Van Weyva, do you need a half a minute?
I will take just a literal half a minute. All right. Mr. Rincon just showed you a document that talks about subcontracting. That's not signed by anybody. I just want to reiterate Mr. Paxton's point. We're looking at the four corners of a document. Okay. And then Mr. Rincon's entire argument here is that Emma Lopez said, hey, they may have gotten some sort of consent during the risk review. So I just want to clear this up for the court. I want to show you Ms. Lopez's deposition. All right. Right here, she says, I am not familiar with Landstar's statement of work, but generally speaking, when a service provider is authorized to subcontract, that is stated in the statement of work along with the services approved to subcontract. There's nothing there. We don't know what services, if any, they were allowed to subcontract. She pointed everyone that's in the Zoom call to the statement of work. And guess what the statement of work says? Please get written consent from expediters before you broker loads. This is circular, Your Honor. He's just going to keep doing this until he finds somebody that says what he wants them to say. It's right there, as Mr. Paxton says, in plain English. And so that's all I have, Your Honor.
All right. Okay, I think I have everything I need on the motion to compel. The court respectfully denies the motion to compel at this time. We can proceed on the motion. Well, let's see. Let's go to expeditors. No evidence motion, please.
Judge, we filed both a traditional and no evidence motion for summary judgment. We then gave an amended notice of hearing that we will only proceed on our no evidence motion today. Mm-hmm. Judge, we've also provided the court with case law. I think two different courts of appeals have specifically addressed this issue better than the others have and stated that a co-defendant has no standing to oppose another defendant's motion for summary judgment. Judge, with that said, the plaintiff did file a response. I don't know if they did incorporate by reference some additional pleadings, some additional responses, but I don't think that qualifies as competent summary judgment evidence under Rule 166AI. There's no affidavits, there's no deposition transcripts. There's nothing like that in response to our motion for summary judgment. I think what they're trying to do is they're trying to be very narrow as far as what they think our motion for summary judgment should address and what it would resolve. And Judge, I don't need to parse it. I'm not here to characterize the no evidence motion for summary judgment. I'm just here to say that we're entitled to our motion for summary judgment. I'm not trying to get into the issue. I think it would only be res judicata, collateral estoppel, as to my client and my client only. It's not going to prove or disprove anything as to Mr. Rincon's client. It's just going to let us out of the case. And so I'm not trying to lock horns with Mr. Rincon. I'm not trying to do anything that I want to stay in my lane on that no evidence motion for summary judgment. I'll say it that way.
All right, I'm sorry. I had something else open here and I think I started to confuse myself. Mr. Villanueva, you said you had a response, or did I hear that there was a response?
We did respond, Your Honor, to Expeditors' no evidence motion for summary judgment, and I'll rely on that response in that briefing, Your Honor. And what I will say is that we agree with the testimony they've given and the facts that they've pleaded, that they entrusted the shipment to Landstar as a carrier, that they did not consent to broker the load, and that they had no idea that an unfit carrier would be moving this freight. So with that, the only way that we would have, I believe, an avenue against Expeditors is if they knew about the unlawful and the illegally brokered load. And if they did know, then they would have been acquiescent in that, and they would have been a part of this unlawful brokering scheme. But that would only be if the court found that, and I don't believe the evidence shows that. I believe the evidence shows that Landstar was the carrier. So with that, I'll rely on the briefing that we've done. That's sort of our position in the case with regards to Expeditors. So I'll be very short and succinct with my response on that.
Judge, may I close?
Your Honor, I did file a response, and I understand Mr. Paxton's position that I don't have standing or it's moot. May I address the court on this?
Well, Mr. Rincon, I tend to agree with Mr. Paxton. I don't believe you have standing in terms of this no evidence motion. I'm happy if you want to put something on the record.
Well, yes, Your Honor. Well, we have demonstrated in the response that was filed, we cited to the court an opinion, Blankenship versus Pierce. It's a 3rd District Court of Appeals case in Austin. And there's a footnote that reads that when a co-defendant has a vital interest in a motion for summary judgment that is raised by a co-defendant, it does have standing to voice and have an opposition to the motion considered. So there is law that we've cited that does provide standing, number one, to Landstar. But number two, in the motion.
Judge, may I just respond to the standing issue very quickly? I'll just say one thing.
Not sure that Mr. Rincon was done on
Yeah,
that.
I would just one thing. So Mr. Villanueva, in their response, they did proffer summary judgment evidence in opposition to the plaintiff's motion. Excuse me, they proffered summary judgment evidence in opposition to the expediter motion. And I was confused as to what part of this motion was proceeding or not proceeding, but Your Honor has sworn testimony that from the perspective in the record is creating a fact issue. Where I take umbrage and exception with the motion for summary judgment on behalf of Landstar is that in the motion, Expediter says that Landstar was retained in the capacity as a motor carrier, and that it was not consented to broker this load, all of which is refuted with summary judgment evidence. You know, we got notification of this pull down officially just now, presumably, and I just want the record to reflect that there is controverting evidence on those points from Landstar. So with that, I'll rest.
Judge, the case he cites, I believe, deals with a co-defendant, and it's whether or not indemnity would be owed. There's no claim for indemnity by Mr. Rincon's client against mine, and nor can there be. And so I don't think that case is applicable at all. That would be the hypothetical situation where indemnity would be injured or affected by the court's ruling. That's not the case here. He has no interest in this summary judgment by a co-defendant, and I think the cases we cited are the ones that obtain. But Judge, let me say this: we have 6 items that are no evidence motion for summary judgment, and the plaintiff has a response that simply adopts some other pleadings. And I don't think you've already heard from Mr. Villanueva. I don't need to speak for him. But Judge, I'm just going to say that, for instance, number 4, we move for summary judgment that defendant expediters negligently hired, supervised, retained, trained, or entrusted the subject load to Landstar. Landstar is not objecting to that. Plaintiff's not objecting to that. And on that item alone, we're entitled to summary judgment. And so there's 6 items there, and all 6 would have to be negated for us to be denied summary judgment today. I don't think that's where we're going today. And so, Judge, the dispute will continue. I understand that Mr. Rincon will continue to send subpoenas to my client, and we will continue to respond. And if he can ask his people who the most likely person or representative they've dealt with over the time and can identify that person, I'll produce that person. But again, Judge, are we entitled to summary judgment today? Yes, we are. And I think both us and the plaintiff, the plaintiff with the characterization of the facts is also agreeing with that.
And Your Honor, if I may just briefly address the issue of standing, since this is Brian Cathy, I'm with Mr. Rincon.
Judge, I'd object to that. Not two people. One counts per client.
I think I'm good, Mr. Cathy. Thank you very much.
Okay.
I want to move on. I do want to, I think I've overloaded myself at my desk. And so on the no evidence motion for summary judgment, you'll have a ruling on that by the end of the day. Okay. I want to move on now to, is it Landstar's motion for summary judgment?
Yes, Your Honor.
Okay.
And Your Honor, I apologize for jumping in. I have a 10:30, so I may jump off, and I just don't want you to see me disappear.
Okay, no worries. No worries. Thank you. Mr. Rincon?
Your Honor, I will be arguing that on behalf of Landstar.
Yes.
Go ahead.
Yes, Your Honor, the driver that was involved in this incident is undisputedly not a W-2 employee of Landstar. You know, that much is clear from the record. Mr. Singh was directly employed by My Universe. And so, you know, that's kind of the background facts. And so what the plaintiffs have done is they have tried to concoct a theory or multiple theories by which they attribute liability for somebody else's employees' conduct to Landstar. And so primarily they assert in their response, they occupy something like 20 plus pages of their argument in response to assert that Mr. Singh is a quote unquote statutory employee of Landstar. And Your Honor, I'd respectfully challenge you to scour their record or their response for a single reference to any statute, either state or federal, that creates a employment relationship between Mr. Singh and Landstar. There's not a single reference anywhere in the entire response to such a statute, despite occupying 20 pages of their response. And if I may briefly show, Your Honor, they rely upon, and respectfully, it's a somewhat I don't want to say confusing area, but a lot of plaintiffs like to confuse the area. And so one of the things they address at length is what's called truth in leasing regulations in the federal motor carrier safety regulations. And those basically require certain provisions if, a motor carrier leases equipment from a driver who's not a motor carrier. They identify certain items that you'd have to have in that type of lease. That's not at all what happened in this case. You have a licensed motor carrier that employed Mr. Singh and Landstar, a completely separate entity that holds a broker's license, and a federal motor carrier safety regulation. And so what they've done is they've basically cited these provisions and included excerpts from what those terms of this lease that doesn't exist are to create this statutory duty. And so at one point in time, Your Honor, there was, some confusion about what the effect of such a lease was. And so the federal government undertook to clarify precisely what the effect of their truth in leasing regulations were. And so when the regulations apply, the government in 1992 amended the regulations and provided nothing in these provisions is intended to affect whether lessor or driver provided by the lessor is an independent contractor or an employee. So the federal government has expressly rejected the statutory employer type argument that's being articulated by the plaintiffs here. And so, not only is there confusion with respect to that, Your Honor, the fact is that these regulations don't even apply in this situation. And so when you look at the actual provisions they cite, it's not the truth in leasing regulations, which are in subpart B. They go to subpart C, which is an exception for the leasing regulations, Your Honor. And so when you go and you actually click on that, you see exemptions for private carrier leasing and leasing between authorized carriers. So the federal regulations specifically say that a motor carrier can subcontract to another federal motor carrier without incurring vicarious liability. It's just as if, as Mr. Paxton alluded to, for instance, a general contractor hires a subcontractor. The general contractor is not vicariously liable for the acts of the independent contractor in that situation. And that's the precise situation we have in this case, Your Honor. So the federal regulations they cite don't apply, period. And even if they did, they don't establish an employment relationship. At most, they would establish an independent contractor relationship. And so, the general rule is that an independent or somebody who retains an independent contractor is not liable for the acts of the independent contractor. And so that's really where we stand, Your Honor. The plaintiff wants to make this big push that we're the quote unquote motor carrier and, wants to push back on the notion that we're a broker. I think we're the broker in this case, and I'll address that separately in a second, Your Honor. But even if you accept their position that we were a motor carrier, we weren't the motor carrier that was driving at the time of the accident. At most, that would be an independent contractor who was operating as a motor carrier. So the whole notion that, somehow there's a fact issue as to our status as motor carrier versus broker is completely irrelevant. As a matter of law, we're not vicariously responsible for the acts of the driver. And so all of the claims for negligent hiring, negligent retention, negligent supervision are irrelevant because the driver was not our employee, Your Honor. And separately, I think the evidence quite clearly establishes that, undisputedly establishes that Landstar also is a federally authorized broker. And we've cited the abundant federal case law, including at least 3 recent federal circuit courts of appeals that say claims against licensed brokers for any services related to brokerage are precluded as a matter of federal law, Your Honor. And so I don't think, regardless of kind of which path the plaintiff wants to take you down, either the federal motor carrier or the motor carrier path or the brokerage path, those avenues are legally foreclosed as a matter of law. So I think we're entitled to summary judgment on all of plaintiff's claims. Separately, Your Honor, we have also moved for summary judgment on gross negligence, which, as you know, is an important issue in any trial because it allows the plaintiffs to introduce and inject additional themes and arguments that a jury otherwise wouldn't hear. And so it's very critical to any defendant's success at trial to, ensure that only well-supported claims for gross negligence proceed to the jury. And in this case, Your Honor, the plaintiff's response addresses in less than half a page the issue of gross negligence. They spend 37 plus pages arguing other things, and they spend essentially a page arguing gross negligence. They don't address the objective prong, they don't address the subjective prong, and they don't address the vice principal requirement for attribution of gross negligent conduct to a corporate entity. And so all they really do, Your Honor, is they cite two other circumstances in which independent contractors allegedly retained by Landstar were involved in accidents. Completely separate motor carriers, completely separate drivers, completely separate facts. They're completely dissimilar, and they offer no evidence of anything. But more substantively, even if you looked past that and you said, well, that might create a fact issue on the objective or subjective prong, you still never get to the issue of corporate gross negligence, which requires basically an act of the corporation. The plaintiffs in their response don't cite anything, any specific act by Landstar, by a vice principal with managerial authority that could be attributed for purposes of gross negligence. The closest they even come is they say Landstar ratified the acts of this non-employee by essentially allowing the delivery to subsequently occur. But the Texas law is quite clear, Your Honor, that that doesn't amount to ratification. A failure to discipline employees is not ratification. Ratification requires affirmative conduct that blesses the conduct with full knowledge of all of the relevant facts. And the plaintiffs don't even address any of those issues, Your Honor. So I think quite clearly Landstar should be out of this case. Plaintiffs have their right to recovery against Mr. Singh and his statutory and actual employer, My Universe. But there's just no fact issue, or legal avenue for recovery against Landstar, and certainly not the recovery of punitive damages, Your Honor. And so for all those reasons, we would respectfully ask that Landstar's motion for summary judgment be granted.
And Your Honor, just one of the points in it, there is also this preemption defense that I believe Mr. Cathy is also going to address.
Yes, Your Honor, I did, and I apologize if I didn't fully articulate it as succinctly as I probably should, or elaborate on as well as I could. But this relates to the issue of brokerage and the status of Landstar in this case. As I alluded to, the plaintiff's primary argument is we're the motor carrier, but separately, the evidence establishes that we are the broker, and under the federal statutes, particularly the Federal Aviation Administration Authorization Act, states that no state may enact or enforce a law or regulation related to the services of brokerage. And so we cited abundant case law, Your Honor, interpreting and applying that. And we've some of those cases, for instance, out of the last 2 years, you have Yee versus Global Trans Enterprises out of the 7th Circuit, Aspen American Insurance out of the 11th Circuit, and then you have another case actually involving Landstar directly in the 7th Circuit as well, Your Honor, that make clear that the plaintiffs are not allowed to assert these type of negligence-based claims against a broker because the federal regulations effectively preempt all of the state law in this area. What the plaintiffs want to do with these type of claims against brokerage or licensed brokers, Your Honor, is they want to raise the standard of care beyond what the federal regulations require. And the federal government has said that that is not a proper basis for state negligence claims. Landstar, complied with all of its regulatory obligations as a broker, and there's just no valid basis for the assertion of state law claims, which are preempted, as a matter of law, Your Honor. But ultimately, as I alluded to, I think that issue, is certainly there. But, you know, the plaintiff's argument, as I kind of understand it, is that we're the motor carrier, but even accepting that, Your Honor, there's no basis for legal liability.
All right. Mr. Villanueva, before I hear from you, let me check in with Miss Deborah. Deborah, do we need a minute? Yes? Okay. We're going to take a quick break if we can get off of YouTube, please.